Good morning, good afternoon, good evening. Welcome to the Roundtable on the challenges in the WTO dispute settlement system. Welcome to all of the participants and to our guest speakers. Thank you very much for being with us today. We have allotted an hour and a half to this roundtable, and I'd like to first thank my colleague Tania Herrera from the Legal Affairs Division for organizing this roundtable. Thank you very much. And I would like to give now the floor to our colleague Carlo Gamberale. He's a counselor in the Market Access Division of the WTO. He has 24 years of experience in international negotiations and public international law. He has worked on numerous, over 20 appeals and arbitrations in the WTO Appellate Body Secretariat, and he will be moderating this roundtable. So I'd like to ask also participants, those who can turn on the camera, to perhaps switch on your camera to make this roundtable more interactive. And without further ado, I'd like to give the floor to Carlo, and thank you again to all of the speakers for being with us, and have a nice interactive discussion. You have the floor, Carlo.
Thank you very much, Alicia. Thank you very much for the introduction, and thank you to the ITTC division for organizing this and for giving us this opportunity of being here, and to the speakers, especially, who will be sort of talking to you today. Before I introduce the format and how we do this, I just want to say in a preliminary way that you're very lucky. We're very lucky to have the speakers here today. In my experience, you will normally get together if there is a WTO dispute. I mean, you might see them in the same room if there is a WTO dispute. Otherwise, it's pretty difficult to get all of them together. That said, what I propose to do is that we give each one of them about 10 minutes to speak, to make a presentation on a number of points that are about WTO dispute settlement, and specifically what are the challenges that WTO dispute settlement is actually facing. Why do you think that such challenges are there for the WTO, and how can members eventually overcome these challenges? So these are the themes. We'll give them, each one of them, 10 minutes, and then 5 minutes to the other panelists to respond to the main speaker, and then we'll open the floor for questions from you. So if that is okay, I would like to introduce our first speaker, who is Natasha Spisba, from the Australian mission at the WTO. Natasha is a legal counselor at the mission of Australia since 2019, but she's been in dispute settlement for a long time, at least since 2010. And we know her from before she joined the mission, because she defended Australia. She presented cases for Australia in WTO dispute settlement. More notably and recently, she was the lead counsel for Australia in the Australia plain packaging dispute that you all know. But she also represented Australia as a third party in numerous other disputes. So we're very happy that she joined us today. And Natasha, you have the floor.
Thank you very much, Carlo. I wanted to thank you, actually, the team very much for the opportunity to speak on today's panel regarding this critical issue. The WTO dispute settlement system is very dear to my heart. I actually started my career working in international human rights law. And it was, in fact, the WTO's dispute settlement system that prompted my shift to international trade law entirely, because it provided this meaningful and valuable ability to hold states accountable to their obligations through a mechanism that was compulsory and substantive and enforceable. And I continue to be passionate about ensuring that the system provides a way for trade disputes to be settled according to the rule of law, rather than on the basis of the relative power or the strategic motivations of the disputing parties. So unfortunately, as everyone is well aware, there are a number of challenges that the system is currently facing. For me, the main overarching challenge that you would be aware of is that the system is unable at the moment to deliver the binding, enforceable resolution of a dispute in the absence of a functioning second tier. Because the rules still provide recourse to appellate review of panel reports, even though those appeals can't actually be heard since the appellate body is no longer functioning, we have seen these appeals into the void left by the non-functioning appellate body become a routine occurrence. And this, for me, is the critical challenge the system is facing. But there are others that I think it's important to mention. A related challenge to that overarching one is also the sense of advantage that some members have about this inability to be held account for breaches of WTO rules. Because now, for the first time, if a member is found by a panel to have breached its obligations, they can avoid negative consequences of that by appealing into the void, so that the adverse report can't be adopted or enforced against the member. And this fundamentally goes against the structure that was set up when the WTO was created, where all members, in exchange for the rights that they accrue as WTO members, are subject to the dispute settlement system. And unlike in other areas of international law, there was no voluntary opt-in where countries could choose not to submit to the jurisdiction of the dispute settlement system while still enjoying the benefits of being a WTO member. I do want to note that not every appeal into the void, of course, is opportunistic. The system was set up with a second tier for review as part of the bargain for making the system binding. Because if disputes bind sovereign members, it's important to ensure that those decisions are robust and well-reasoned and free from legal error. And that critical interest hasn't evaporated simply because the appellate body is currently unable to discharge this role. So it's legitimate for members to still wish to exercise their right to appeal a panel decision, even where that appeal cannot currently be heard. One other challenge that the system is currently facing, which affects efforts to resolve the current crisis, is the growing sense of divergence about what members, including major users of the dispute settlement system, want the system to deliver. I think most of you would be aware that when the US began blocking appointments of the appellate body to replace outgoing members, it had cited originally fairly narrow procedural concerns with the way the appellate body was operating. Over time, those concerns expanded, but they were still focused primarily on claims with the way the AB was operating and that it was not consistent with the rules set out in the dispute settlement understanding. Now, we've seen a shift in US sentiment on this under the new administration, with Ambassador Tai suggesting that we need to revisit the system as a whole to interrogate how effective it is in resolving disputes between members and whether having this avenue for legal settlement is in fact preventing members from coming together to settle their disputes through negotiations. And one other challenge that I wanted to mention that is of a slightly different order is the fact that it's being caught up in broader geopolitical tensions. So this, of course, reflects the interconnected nature of our world and the clear links between trade and other forms of international relations between sovereign states. But I mention it here because it has created challenges for the perceived legitimacy of the WTO's dispute settlement system and for the system to try to navigate the blurred lines between law and politics, which we have seen in recent years, for example, with the system being asked to rule on the parameters of what the essential security exception allows in the context of highly charged political conflicts. In terms of the why do we think the WTO is facing such challenges? I think, there's this phrase about the system having been a victim of its own success. And I think in part that is true. A system that is able to deliver binding outcomes to resolve trade disputes is going to be increasingly called upon to do that. And the more the system is used, the more demands there are on the system. And I stress this is not intended to offend our distinguished private sector colleagues that are on the panel, but of course the increasing recourse to private firms for representation in WTO dispute settlement proceedings has also been a contributing factor to the sense of the system becoming more costly and more litigious and more complex over time. Of course, the length of time that disputes take to resolve has an impact on the effectiveness of the system, because the WTO system doesn't provide any recourse to retrospective remedies. So the longer a dispute takes to resolve, the longer the damage to a complaining member from the measure that's being challenged still being in place. I think also key features of the system that are there to ensure the quality of decision making, they create certain litigation incentives that have been exploited over time, and this is also natural. We've seen this most clearly in, over time, almost every panel report being appealed to the appellate body, even where the claims of legal error are not particularly credible. But when you have a mechanism that will delay the final resolution of the dispute and that provides an opportunity to challenge an adverse outcome, there is a strong incentive to take this up. I think more broadly than the strict mechanism of operation is also that some members have developed over time a sense of imbalance with respect to accountability and enforcement. And that's both due to a sense of the way the appellate body was operating, perceptions that the appellate body had gotten things wrong or gone too far in its review of first instance decisions, and that in the course of doing that, effectively changed what the rules were intended to prohibit and intended to allow. And we've seen that most in the adjudication of trade remedies disputes, the claims related to this in trade remedies disputes. But there's also due to a sense that the rules themselves don't cover all forms of harmful trade-related behaviour. So there has been a sense of an imbalance between the members that can be held to account through the dispute settlement system on the basis of the rules that exist, and those members who the system can't discipline because the rules to constrain the types of behaviour that they are perhaps contributing have not yet been agreed. And I think that that has affected some members' disposition towards wanting to be bound by the system. I think turning to the third question that we've been asked to address, how can members in the WTO overcome such challenges? This is obviously a very difficult question to seek to answer given the nature of the challenges and how we got here. One thing I will note that at least temporarily, you might be aware of the multi-party interim appeal arbitration arrangement. This is an arrangement of a subset of WTO members that was designed to preserve the avenue for recourse to second-tier review in the absence of a functioning appellate body. And that can help overcome the first two challenges in ensuring that panel reports aren't appealed into the void, but are either adopted or appealed to an alternative appellate process. That, of course, is no substitute for a multilateral solution that restores automatic and binding resolution of disputes, which I said before is the fundamental underpinning of the WTO when it was created. I think obviously there's a need to come together as a membership to work through perceived problems with the system's prior operation. And this is something that we are hopeful we'll be able to begin shortly this year in order to advance a way forward in restoring a fully functioning WTO dispute settlement system. But the challenges here will be, extremely fraught. As I mentioned, we've seen divergence already in terms of what some major users want from the system. Their interest in what the system can deliver has shifted over time. And so bringing us all together to seek to work through what the system should provide is no small undertaking. But I think it will be useful to draw upon the fact that we have the dispute settlement understanding that is the basis of the system as agreed by all members. And I think that certainly if most of the focus can be looking at aspects of practice and trying to find solutions for where the practice hasn't mirrored the rules, that will be a positive way forward. And finally, I just note that given the broader sorts of concerns, reviving the negotiating function of the WTO to enable new rules to be agreed that cover the types of trade-related behaviour that members perceive are currently impacting will also be an important way to relieve pressure on the WTO dispute settlement system and restore any perceptions of imbalance in accountability. Thank you.
Thank you very much, Natasha, for this absolutely complete and precise introduction of the issues. At this point, I would like to ask the other panelists whether they have any quick reactions to Natasha's presentation. Well, I'm sure you can address in your own comments the same issues. On my side, I found this extremely interesting. I think some of the issues that Natasha raised, raised for me, and I'm sure that the other panelists will address also the question to what extent this crisis is affecting members in a different way, depending on the type of member, what is developing country, and the size, of course, of the member in terms of trade and position in international trade. But this is something that I'm sure the other panelists will also address. Now, I would like to ask the participants whether they have any questions for our panelists at this particular point in time, knowing that we can always also come back later with more questions. Okay, so let's then, if there are no questions at this point in time, I'd like to move to our next panelist. And as I said, if you have questions, even as the presentation continues, don't hesitate in raising them in the chat as well. We can address them or questions also at the end. So the next speaker on my list is Mr. Alan Janovic, who, as some of us know, as some of you may know, is a partner with Akin Gump in Geneva, where he leads Akin Gump's international trade practice. Alan represents foreign governments and multinational cooperation in dispute settlement before the WTO and other international dispute resolution mechanisms. Alan, prior to that, is also a sort of like old acquaintance, colleague, and friend of mine, as we worked together for 12 years as the WTO Appellate Body Secretary. So Alan, the floor is yours. So Alan, I think you are muted. You can see you very small in the picture, but it seems that we certainly cannot hear you. Can we unmute Alan like long distance or? Oh, there you are. I think we can hear you, Alan. We can hear you.
Okay, good. Sorry. Thank you very much. I was just saying that I wanted to thank you and Tanya for the invitation. It's a pleasure to be here and see faces that I haven't seen in a while. I recognize some of the names of the participants, and I'm glad that we'll have a chance to see them. I think I can be brief in my remarks because I generally agree with Natasha's assessment of the situation. I think it was a very accurate assessment, and I generally share her diagnosis of the situation and her recommendations for moving forward. I guess before focusing on the problems, I want to emphasize that there are a lot of things that are working well. Panels, in the most part, are working extremely well, I would say. There is a lot that is being done at the panel level that sometimes gets lost in the crisis. Panels are proceeding with cases and are adjudicating cases and are producing very high quality panel reports. And I think we need to always be conscious of that and highlight that, because that continues to happen every day. And it's a good thing. So the system is working partly. There are aspects of the system that are working quite well. I agree with Natasha that the main problem is that eventually panel reports can be appealed into the void, and that means two things. One is that the panel report becomes unenforceable, but also from the respondent side, there are respondents that in good faith may disagree with the panel report and would have a right to have that panel report reviewed on appeal. And it is a problem for them too. There are some members who are gaming the system, as Natasha said, and there are some members who are being robbed of the right to have that review. Even with that happening, there are also sort of good things happening outside the WTO. There is a genuine attempt by some countries, and we've seen it particularly with the US and the EU, to reduce trade frictions. And there has been a lot of progress moving forward on a lot of difficult issues in the last 2 years. I think that's something to be welcomed generally. I mean, the objective of the system is to resolve disputes, to settle disputes. That is happening right now outside of the system bilaterally. That is not necessarily a bad thing. That's actually a good thing, and it should be encouraged. It will have implications because some of the settlements have aspects that may not be necessarily consistent with WTO rules. And that is going to generate new frictions with respect to, especially with those who are being left out of those settlements. And so, there is an effort to resolve disputes among some members, but those efforts may increase frictions with another group of members. And we are seeing generally a fragmentation of the system, where we have a core group of members who are sort of very active in the system and that continue to use the system, and a few members who are now prefer to stay out on the margins of the system. A few members for which the system will deliver enforceable results, and a few members for which the system will be incapable of delivering enforceable results. And it's not just the United States. The United States has played a big role in it, but there are other members taking advantage. I'm sure Natasha and Marco will speak a bit more about sort of their experience in the case of the sugar case with India. But that's a very large economy that has chosen to remain on the margins of the system and has so far refused to sort of participate in some of the temporary measures that have been put in place. So what can be done? I think the best even though it's suboptimal, the best solution is the MPIA, and I applaud Guatemala and Australia for the leadership on that. The MPIA is a good solution in the current context. If more members could give consideration to joining the MPIA, that would be a good thing. If the MPIA were to sort of broaden its membership, it would be a good thing. It is meant to be a temporary arrangement. I don't think those who are participating in it want it to be permanent, but as a temporary arrangement, it is a good alternative. And I think that one of the best things that could be done is for other members to give serious consideration to the advantages of joining it. I think we'll have to be realistic about the broader context, and I think Natasha's right in pointing that out. I would go a bit further, and we have a situation where it's not only that, we have members who have different views about the value of the system. Clearly, for some members, the system has less value than for others. I think for the United States right now, we have to be realistic. They see their domestic unilateral tools as more valuable than multilateral dispute settlement. but that raises the point that was raised earlier, which is, you know, the United States is a very big economy, and that is why it can use some domestic measures more effectively. A smaller economy will be unable to do that. And so it does create problems where you have a system where larger economies are able to use other tools that would be unavailable to smaller economies. And it is a cause of systemic concern in my view. The other broader problem is, I think we've entered an era where managed trade has become trendy again. I mean, to me, the United States right now is pursuing managed trade. It's not interested in open trade. The United States is doing what we used to do in Latin America 30 years ago, and what the United States used to tell us not to do. But that is what it is intending to do today. So it's not interested in an open system. It's interested in a managed system. And it's interesting in being able to influence trade flows in a way that it considers advantageous. And in that context, the system of the WTO may not be the system that they see as most advantageous. So we'll have to continue to make a case of why WTO rules are the most efficient way forward, why the WTO system offers solutions, why overall having a system that adjudicates disputes on the basis of the rule of law is in the interest of everyone. But it's going to be a challenge going forward, unfortunately. So I'll leave it there for now. Oh, and sorry, and just one last one. I guess I think there are improvements to be had. I think it's important that improvements reflect convergence among members and not just sort of the interest of a few. That's going to be a challenge. I think where there may be most room for improvement is in the implementation stage. Dispute settlement, the WTO is not fast, but at the same time, part of that is because the parties sometimes don't want to move it faster, and because it's difficult to go faster at the panel stage, but perhaps in the implementation stage, there are more opportunities to think about streamlining the process and making sure that once you do have a ruling, it can be enforced more quickly. And I'll stop there. Thank you, Carlo.
Thank you, Alan, for your very insightful intervention. At this point, I would like to ask, and I have a question for Natasha from a participant regarding a previous intervention. But before I go to that question, I'd like to ask the other panelists whether they have comments, quick reactions to Alan's intervention. Natasha.
Thank you. Just briefly, I want to echo Alan's point about the fact that there's certainly room for improvement in the operation of the system. And I think that some of the factors that we both mentioned in terms of challenges that are facing the system, those are real things that do need to be addressed to ensure that the system is perceived as offering a useful, relevant, prompt way to settle disputes. And so those aspects, I think that there is actually a reasonable degree of commonality among members, which is hopeful. But I just wanted to echo that, yes, we certainly agree that there is a need for some system reform.
Thank you very much, Natasha. If I may, on one thing Alan said, I'd like to pick, and I fully agree with him. We should also look at the positive side of where we have settlement, that we've seen a number of settlements taking place, and that's obviously, it's a win-win in a WTO situation if a case can be settled. Nonetheless, that is also overshadowed and in a sense counterbalanced by the fact that we now, I mean, I haven't done the math, but some of you probably have, we have an appeal rate that is soared into the 80 or 90%, while that used to stay at 60%. So this is an indication of all these disputes that unfortunately remain without the solution adopted. I would like now to read the participant questions for Natasha, as her intervention is still quite fresh, rather than leave it at the end, and is the following. So a participant asked Natasha whether she recalled that she mentioned the shift in the US administration regarding the appellate body, and he's wondering whether she could share for her impression on the reasons behind that shift. Natasha.
Thank you very much. Well, it's always dangerous to speculate about the reasons for something when they aren't your reasons. But I think, I mean, in some ways, there are different views about whether there has in fact been a shift in US position. And I should mention that there is a view that the US has held these broader concerns about the use of the dispute settlement system and its operation, but it was less forthcoming before because it had no appetite to actually move forward in seeking to solve problems. It was content to leave the stasis, and that now there's actually just a greater preparedness to move on ensuring that the system can in fact be restored to a proper functioning. So I should highlight that there are a variety of views on whether there has even been a shift. But I would like to think that in some ways, the heightened US engagement that we're starting to see emerge at this point is positive. We can't move forward in resolving a multilateral functioning dispute settlement system without the US. That's impossible. And so we need them to be engaged in wanting to move forward. If that means that the debate is situated more broadly than it had been a number of years ago, that's a reality that we just have to grapple with. But I think that certainly, I mean, some of the factors that I was alluding to in my presentation about this perception of imbalance in accountability and enforceability, I think those are very motivating concerns for the US's experience in the dispute settlement system. I think that the factors that both Alan mentioned and that Carlos picked up on about the being able to settle major disputes outside of the WTO's dispute settlement system and the kind of increased cooperation that we've seen in particular between the EU and the US with being able to solve the Section 232 disputes, for instance, and also dealing with the large civil aircraft disputes. These are positive examples. They do frame, I think that they motivate the US experience of the dispute settlement system as having been perhaps unable to deliver certain solutions that it has otherwise been able to obtain politically. But as both Alan and Carlo mentioned, these factors are due to the economic and political power that the United States has. And when we think about the WTO dispute settlement system as a whole, we need to think about what it offers the entire membership. And the fact that, as I said at the start of my presentation, that it's important to ensure that there is an avenue for resolving trade disputes that is on the basis of what the rules provide, rather than the relative power of the disputing parties or the leverage that either is able to offer or their motivation to come together, where both of them have been engaging in the kinds of conduct that they're challenging in the other. Those disputes perhaps lend themselves more to a political negotiation rather than litigation. But that's not a reflection of failings of the system itself. Thanks.
Thank you very much, Natasha, for your response. At this point, if there are no questions from the participants, I would like to move to our next, the next speaker on my list, our next speaker, who is Mr. Jasper Wouters. And Jasper is a partner and a litigator who leads the Geneva International Trade Practice of Whiting case. Jasper has more than 20 years experience in WTO dispute settlement, both in private practice and as a member of the rule divisions in the WTO Secretariat, so also one of my colleagues a long time ago. So Jasper, you have the floor.
Thank you, Carlo. I noticed, by the way, that you introduced Alan as a former colleague and friend, while you only mentioned colleague. It's great being here with you. It's a pity that we can't be together, which I think does lead to a more sort of lively debate and is always more easy to interact with one another. But you know, such is life. Let's try to make the most of this session. Look, I think Natasha gave a very good overview of the situation in a very clear manner, and I share most of what of her views and what she has said. I think I differ in terms of the solutions. We'll come to that in a minute, and the same I think with Alan. I would say the system, in my view, faces an existential threat. This is something that needs to be resolved, or it could mean the end of dispute settlement the way we know it. The criticism of, in particular, the United States, but has now, of course, been accepted and has been voiced by other members as well, has undermined the credibility of the dispute settlement system at the WTO. Its actions have led to non-functioning dispute settlement mechanism, because we cannot get disputes resolved, which has a particular effect, of course, on the mechanism and on the expectations of members. And I would say more in general, it adds to the general crisis that the WTO is in. Let's not forget, we're talking about our little world of dispute settlement, but there was a lot of criticism with respect to the failure of the WTO to complete the Doha development agenda, the round of negotiations, which started back in 2001. No new rules have been agreed upon other than for relatively minor the developments such as trade facilitation. So this organization was actually reduced already to dispute settlement. Now, if that doesn't work anymore, what remains of the World Trade Organization? So it really is an existential threat, not only to the dispute settlement system of the WTO, but potentially to the WTO itself. At least that to me is the major challenge. But and again, seeing the participants, you guys may think, look, all that's fair and well, but nevertheless, disputes are being brought to panels, and I need to deal with those issues. There are daily challenges for people participating in the WTO dispute settlement mechanism, and they relate to, and I think Natasha referred to it as well, the complexity of some of these disputes. Natasha blames it on the participation of private practitioners such as ourselves. I personally don't think that that's entirely correct. I think in general, the system has developed not so much because of the private practitioners, but simply because of more and more cases being filed and potentially an appellate body complicating matters or opening avenues for further litigation and argument that have led to more sort of a more complex legal environment that requires assistance. There are general questions also from daily perspective, I would say, in terms of the effectiveness of the system. Ultimately, which issues are really resolved after 2-4 years? I mean, some of us have been involved in the aircraft dispute. At the end of the day, what, 15 years of litigation for what? A very rather sort of innocent agreement between the US and the EU. Airbus still that same company after 40 years of subsidization. Not much has changed in that respect, right? And we see many of these disputes where you wonder, other than having a further clarification of what Article 2.2.1.1 means, what really did we resolve in this dispute? So there is a question, I often, when we discuss with clients, they say, what is going to happen? And sometimes I have to say, well, not much. Don't worry too much about it. Don't get too nervous when you're being challenged, because it will take time and you'll have a reasonable period of time to implement, and the implementation is really left to your discretion. So, but of course, that begs the question, what ultimately is the value added of the dispute settlement mechanism? So those are a couple of to me, the daily challenges that the system faces. Now, if we go back to that existential threat, Carlo, you raised the question, what caused this? And we heard from Natasha, I think, in a very comprehensive manner, what caused it. If we sort of bring it down to, I think, more concrete issues that triggered the reaction by the United States. And of course, there has been a criticism for a long time, but really the trigger to me has been a series of issues with respect to trade remedies, anti-dumping in particular. There's this whole zeroing case law, but more in general, I think the way panels, and in particular in the appellate body, have approached some of the disciplines in the anti-dumping agreement, how they fail to give a role to the special standard of review in the anti-dumping agreement has been a big issue. Second big issue, of course, no one can deny China, and especially in the context of the subsidies agreement. How do you deal with a state-driven economy, and while you have rules that relate to subsidization that don't really fit with the structure of the economy in that country, and how do you address that, and the apparent failure of the system to address it in a correct manner. Then I would say also more in general, the fact that the WTO hasn't indeed been able to complete the Doha development agenda, that the rules negotiations have stalled. So the failure of the system as such clearly has not helped the way we view the dispute settlement mechanism. And then I think if you look a little bit more closely at the appellate body, which has received the brunt of the criticism, there has been some, in my view, unwarranted intellectual arrogance on the side of the appellate body. For a long time, I think the appellate body, the community, saw the success of the appellate body in the sense that, many countries go to the appellate body and ask for its intervention, that the high appeal rate was seen as a success. To me, it has always been a failure. I don't think it's a good development that so many cases get appealed. It undermines the credibility of the panel system, and the appellate body in the early days used very harsh language sometimes when it was reversing panel reports. And we have with Carlo and Alan, two former colleagues in the appellate body. I was at that sort of other level, the first instance level, the panel level, and I mean, I don't know, we were as reasonable as we thought in our interpretation, but bam, we got slammed by the appellate. I said, why? Where does this come from? Why do you need to replace one set of words by another set of words and then say this necessarily leads to a different conclusion? So there was that arrogance from the appellate body, which I don't think has been very good for the system. Add to that a couple of process issues in terms of the length of time that some of these cases have taken, the way certain issues were addressed, such as facts in Article 11 point of the DSU. But I think those were more sort of technical issues. Now, what do we do to overcome it? I don't know, Carlo. I mean, that's the $1 million question. I would say at the moment, the way everything I hear about sort of the position of the United States and whatever has been happening, I think we need to get rid of every taboo. And that could potentially include getting rid of the appellate body. Why not? People talk, and I've heard it a couple of times again today, the right to appeal, the right to appeal, the right to appeal. In public international law, it's not very common to have an appellate body. You have it in criminal law, right? Natasha started her career in human rights. I started it in international humanitarian law. I was working at the War Crimes Tribunal for the former Yugoslavia, which does have an appeals chamber. Why? Because you're about to imprison people for the rest of their life. So that makes sense. But in public international law, there's one International Court of Justice, there's one International Law of the Sea Tribunal. It's already asking for that international review. In investment arbitration, where I work as well, you have one investment arbitration panel, that's it, right? And awarding damages into the millions or billions sometimes. It's not necessarily, so it was an experiment. And maybe we have to come to a conclusion that the experiment wasn't successful, because perhaps inevitably putting a standing appellate body on top of a panel leads to a more rigid case law and a repetition of that same approach and a feeling of, does it still make sense to have a panel if ultimately we wait for the appellate body? So I think it's a possibility. I'm not saying that that's necessarily so, but in my view, we've come to a moment where you need to consider those things and either getting rid of the appellate body or at least strengthening the credibility of the panel level, where to a certain extent, that's where the experts are sitting. And maybe we can think of something of having a stronger panel composition process with real experts on anti-dumping, real experts on services, on intellectual property, rather than this bizarre mixture that we have sometimes of a diplomat or there's an academic and an economist. A stronger panel composition process, better panelists, perhaps avoids the need to take so many cases to the appellate body. And of course, one other issue that hasn't been mentioned here, what's the role of the Secretariat in all of this? Because if we talk about imbalances, I often think that one of the imbalances that we've seen is a very strong, very high quality WTO Secretariat, and not always necessarily the same quality on the side of the panel or the appellate body members. which necessarily means that, oh, you know, the expertise comes from the Secretariat. Is that good, or does that Secretariat acts almost in a quasi-academic manner rather than resolving the issue? So I think those are a couple of issues to think about. And finally, something that people have mentioned as well, a greater member review. Should we do more with the possibility of members to review what the appellate body or panels have done before adopting a report, member review commission, and so on and so forth? Those are sort of issues beyond the obvious, but I think we need to start thinking of them. As with respect to the MPIA, I know a lot of people here, especially among the panelists, are fans of the MPIA. I am not. I don't think it's a solution, to be honest. I find it bizarre that in a context of crisis, where one of the main criticisms of the United States has been, hey, the rules are what they are. Don't go beyond that. Don't start inventing things that are not there. You invent something such as the MPIA. You actually change Article 25 into something that clearly it's not meant for. You create a whole procedure around it that's completely outside of the DSU. I don't think that's the right message to send. More importantly, secondly, I think we don't know what the status of the MPIA decisions will be in terms of, you know, what kind of precedent will they set, because ultimately these decisions will not be adopted by the dispute settlement body. They will only be notified. Some members participate, others do not. Who was involved in choosing the standing pool of arbitrators? So a lot of uncertainty that you create. And then there's a political message. What message do you send, saying, hey, you know, you think you can block it, we're going to circumvent you? I don't think that's right. So then comes back to my point is, if you really want to be systemic about these things, say, I accept what a panel has said to me. The panel is a panel of experts that I was involved in composing. And if they think I violated the law, then I violate. So a real systemic player, in my view, should say, I'm not going to appeal. And that's, for example, why I'm so disappointed when the European Union, the first opportunity it got to take that systemic position, decides not to do so and appeals into the void, follows into the footsteps of the United States in a case against Russia. That to me was then you lose the moral high ground. In any case, that's sort of my summary of the situation, not a very promising one.
Thank you very much, Jasper, for this intervention. As you said, free of taboos and then very thought-provoking. I would like to ask at this stage whether the panelists have comments or whether the participants have questions. So I have a question from a participant, which I'll read out to you, Jasper. And he's asking, we have seen concrete proposals from the US on different issues such as transparency, SOEs, market economies, and SDT. Please correct me if I'm wrong, but that seems not to have been the case regarding the appellate body. What the panelists think about this?
So I don't know whether the question is just for me. I mean, it's correct. The United States is completely silent, does not want to talk about the appellate body. And I think if I speak to my colleagues in Washington, they say it's a non-issue. It's buried. They don't want to raise it to a certain extent, and that's the examples that the participant gives are correct. It looks as if the US first wants to establish the rules on substance that then later potentially need to be applied in the situation, because to a certain extent, a lot of the criticism of the United States with respect to the appellate body may also actually be a criticism of the non-existence of rules. So is it the fault of the appellate body that the rules were written the way they were and we're unhappy with the rules the way they're written? Then you need to change the rules. And I think that's what the United States is trying to do before reactivating the dispute settlement mechanism is, can we change those rules? Can we have better disciplines on SOEs, on and elements that they're frustrated about, in particular with respect to China, of course.
Thank you very much, Jasper. Just a couple of things, to add to the discussion, which I found very interesting in Jasper's intervention from a personal point of view. This issue about the circular argument is indeed very dangerous. So if we think that the success of dispute settlement was the sort of the lag and the difficulty with the negotiating mechanism, the solution is not necessarily to bring down dispute settlement. You might end up having none of the two at one point in time, which is the worst case scenario. On the question of whether of the perspective, you know, I can share a personal perspective. Before working for the Appellate Body Secretariat, I did work for a couple of panels, and I was slammed also by the Appellate Body Secretariat in a way that I thought was pretty arrogant back in 1998. Now, what I would like to do is, if there are no other questions or comments from the panelists, I would like to turn to our last, but definitely not least speaker, who's Marco Tullio Molina. Marco is the Deputy Permanent Representative of Guatemala before the World Trade Organization, and also has an extremely lengthy and deep experience in WTO dispute settlement. He's been part to more than 35 disputes in the WTO and in bilateral and regional dispute settlement mechanism. And he's himself acted in various occasions as a panelist and as an arbitrator. Now, one thing we do in dispute settlement, we disclose conflicts. I'm afraid I didn't do this at the beginning, but Marco, like Natasha, like Jasper and Alan are friends. Therefore, you know, that is my conflict today. So Marco, the floor is yours.
Thank you very much, Carlo. And first of all, let me thank the WTO Secretariat for the invitation to speak at this roundtable discussion. I'm very honored to participate at this event with renowned and distinguished friends and colleagues. And I look forward to learning from all of you. We were requested to answer 3 questions, and I don't think that I can add much to what has been already said by my 3 friends that spoke before me. Let me start by talking about the challenges of the dispute settlement mechanism. And I would perhaps mention 2 that in my view are the 2 major challenges. One is how to navigate in a dispute settlement mechanism that is broken, and the other is how to fix such mechanism. And I am trying to divide in a, you know, in a bigger context, you know, the challenges. By not having a fully functional appellate body, the dispute settlement mechanism became unstable. And we all know, it has been explained before me, that members do not have access to many of the features of the mechanism. Today, we don't have a 2-tier system. We have less legal certainty. Most of the times, we don't have binding decisions now because, you know, panel reports are being appealed into the void. And in terms of proceedings, we don't even know how to react when an appeal is being filed. For instance, if you, as an appealee, you have to submit your appealee submission, or everything is suspended, these kind of things, we don't know. So the whole situation creates uncertainty. And the problem is that when deciding to bring dispute to the WTO, the problem is that you can, or you may obtain different outcomes. Appeals into the void. We know that we have more than 20 now appeals into the void. There are certain members that have the possibility to use alternative arbitration appeal mechanisms, but not all members. And there is also the potential adoption of panel reports without an appeal, or the negotiation of mutually agreed solutions, with sometimes, in the current circumstances, with suboptimal results. It depends, again, on the size and the political power of the members that are involved in a dispute. It's not no longer a rules-based, you know, system. So the challenge today is how to navigate in all this uncertainty, and expectations, of course, are to be calibrated on a case-by-case basis. Everything will depend now on who are the disputing parties, and not particularly what are the rules or the issues under consideration. And of course, and I am putting myself in, you know, in the role of advisor to the minister. When my minister asked me, okay, should we bring this dispute to the WTO? My first reaction is, okay, it depends. That member is part of the MPIA or not. That member is recognized for their cooperative or uncooperative approaches. What is the level of importance of the matter of issue in the domestic jurisdiction, etc., etc. So now I agree with Natasha and Jasper that you have to look at the situation of the dispute settlement mechanism in a broader context. And the scenarios are not encouraging, as we heard from previous speakers. Other areas of the WTO are stalled or are facing similar difficulties. Negotiations are not moving. There is a poor rate of compliance with notifications. Members are less capable of resolving their trade concerns in the respective committees. And while members agree that the WTO needs urgent reform, they disagree about the scope and modalities of such reform. And recently, the war in Ukraine is certainly not helping at all. And you start, witnessing certain paralysis in many of the areas of the organization. So these are very challenging times. And in this context, coming back to the dispute settlement mechanism, we have these two major challenges. And on dispute resolution, what we can do? I think that we can only do what we have been doing, and is try to negotiate and encourage others to cooperate. And I take the point made by Alan that it is positive to see more and more members trying to negotiate mutual agreed solutions or to resolve even the disputes before coming to the WTO. This is a positive development, but it doesn't work in other instances, particularly for small developing countries, when you don't have the power to induce compliance or to induce the other party to agree on something. And perhaps the more recent example is our dispute, the sugar dispute with India. At the end, we made every effort to negotiate with India, but we didn't have really any kind of leverage to induce India to sit and negotiate with us. So this is the kind of things that are happening, and you start witnessing that is the consequences of not having a fully functional dispute settlement mechanism. Now, what else we can do? And we are part of the MPIA, which we see as a temporal solution or an alternative solution to the whole situation. I understand Jasper's point that perhaps this is not the best use of Article 25 arbitration, because it was not supposed to be used in this manner, and I fully agree with that. But it is true that it's better than not having, this possibility to appeal panel reports, or that possibility to resolve disputes and make at least binding the decision at the end of the whole proceeding. It's not perfect. It has its limitations. We don't have experience. As you know, we haven't used yet the MPIA or any other arbitration appeal arrangement. But at least there is an alternative. One could argue, okay, but you also have the possibility to adopt a panel report. And again, one of the comments that Natasha made at the beginning of her presentation is that not all appeals are opportunistic. And we need to recognize that fact. And of course, if you have legitimate reasons to appeal a panel report, then at least you have this possibility with the MPIA or any other arbitration appeal arrangement. That it will create some fragmentation in WTO, that's true. That it has its limits, it is true, because it's not a permanent body or even an institution within the WTO dispute settlement mechanism, but at least we have that possibility. Now, on how to fix the system, we need first to understand better the rationale behind the concerns of the United States and better understand its expectations. We should bear in mind that any negotiation on dispute settlement must address the US concern, but without disregarding the concerns of the rest of the WTO members. And this is important because this will be a negotiation among all WTO members. And the challenge will be how to reconcile the different views, interests, and expectations if and when members start considering proposals that may depart from the current system. In this respect, I would like to finalize this presentation with three reflections on what to bear in mind when engaging in discussions to fix the system. And the first is that the US concerns appear to be directed to the way in which, in the US view, the appellate body applied or did not apply the rules. However, the United States does not seem to be arguing or complaining about the design and architecture of the dispute settlement mechanism. On the contrary, if you look at published reports and statements, you will find that the United States has stated that any resolution should not involve an amendment to the DSU. It is true, as Natasha indicated, that Ambassador Tai has suggested revisiting the system as a whole. But to be honest, and I don't want to sound disrespectful, Ambassador Tai's interventions sometimes are very cryptic, and perhaps we should take her interventions with a pinch of salt. And this is because if you read official documents from the US administration, you won't find this kind of, suggestions. Of course, we need to continue our conversations with the United States and to verify if it is still valid, this proposition that they don't want to amend the DSU. Second, in its argumentation, the United States is making a unilateral evaluation about the performance and the decisions taken by the appellate body. They appear to disagree with the merits of the decisions, but it does not seem to argue that the decisions were biased. Basically, the United States is arguing that it would have reached a different conclusion. By looking closer to each of the cases cited by the United States in support of its position, it is worth noting that not all members agree with the United States assessment that, for example, the appellate body created or diminished obligations. So that brings me to the very nature of disputes and the dispute resolution mechanisms in general. When you have two parties disagreeing with a particular legal interpretation and they cannot reach a negotiated outcome, they resort to an adjudicative body who is expected to act in an impartial and objective manner. When the decision is rendered, the disputing parties may agree or disagree with the outcome, and that's inherent in any legal system. So when engaging in dispute resolution mechanisms, part of the calculation must be that the adjudicator may disagree with our own legal interpretation, and even if we consider such interpretation to be correct, we don't have the guarantee that the panel or the appellate body will agree with that legal interpretation. So let's assume that you have a 50-50 chance of succeeding in your argumentation. If you lose, does it mean that the adjudicator got it wrong? And this is the kind of rationale that perhaps the United States needs to understand, and this is my point. When negotiating a solution, the United States needs to understand that there is an intrinsic risk in the use of litigation. You are not going to get 100% of what you want in a particular case. It is true that some cases are very clear. If you have bound tariff and you have an applied tariff that goes beyond the bound tariff, well, that's inconsistent with the WTO agreements, and that's it. But in other instances, you will have a very, ambiguous drafting or ambiguous provision, and then you have 50-50 chance of succeeding or not in your case. So let me conclude then that as a third point, that the WTO dispute settlement mechanism might not be perfect, but no legal system in the world is. So it can certainly be improved. And the question is whether WTO members are better off with a mechanism that is not perfect or with a mechanism that is not fully functional. My point is that when we engage in negotiations to fix the system, we should be mindful that the perfect system doesn't exist. And we should have as an objective, we shouldn't have as an objective to create one that is perfect. And this will be very important to bear in mind because when you see the US complaints, they are aiming at having a perfect system in their view. So if we aim at having a perfect system, we risk not reaching an agreement. And we have to be very clear that the system that we had before, it was working. Not perfectly, but it was working. And perhaps I will conclude my presentation by saying that, or reiterating that we fully agree with what Natasha, Jan, and Alan explained in their presentations, with everything except for the fact that we should consider, the possibility to eliminate the appellate body altogether from the dispute settlement mechanism. Thank you very much.
Thank you. Thank you very much, Marco, for very, very insightful intervention. I would like to ask at this point the other panelists whether they have any comments on Marco's intervention or on each other's previous interventions.
Carlo, Jasper here, if I may.
Please.
Thank you, Marco. I think once again, I mean, all of the speakers it's interesting to hear these different perspectives. I think we're all saying more or less the same thing, sometimes with different emphasis here and there. I was wondering whether you could sort of expand on the way the US sees things and what USTR Tai said. I understand the US position, and I don't know what it's a shift, Natasha, but there's the statements being made about the dispute settlement system should support the negotiating function and should not replace it. I read that as saying a dispute settlement system should be modest. It should accept the limitations of the rules. It should not use whatever constructive ambiguity or general terms of what is reasonable or the definition of causal link to read certain obligations into the agreement which were not specified in that particular way. Maybe it's in sort of a in dubio mitius, hey, don't think because we're unable to negotiate the rules better that you need to take that role upon yourself and saying, okay, so in this position, in this situation, I think boom, and make that decision. Maybe that kind of modesty is what has not come out of the appellate body over the last, 15-20 years. And let me just drop that footnote that I disagree with everything that the United States is doing. I think there's an element of truth in what they're saying. I think there's a lot of things one can say about the appellate body. I've been relatively critical of the appellate body, not so much in respect of the issues that the US is raising, but for many others. I think they killed the safeguards agreement. I don't like what they did to TBT. I think the way the approach SPS is wrong, whatever. But the reasonable people can disagree about these things, right? So there's an element of truth in what the United States is saying. The concerns that they're raising are exaggerated and their actions is completely disproportionate, right? So let's be clear. But if now it doesn't matter what we think. There's an important member that says what it has to say, and we're all starting to adopt that rhetoric anyway. So my question to you is that how do you view the criticism of the United States, and is there something to be said for that indeed in a situation such as these general terms that we use in these agreements, a constructive ambiguity, should indeed the dispute settlement system not have been a little bit more humble in its approach.
Marco, would you like to respond?
Yeah, I think that Jasper has a point, and I fully agree with when he was mentioning, the arrogance of the appellate body. I wouldn't use that word, but perhaps it is true that the approach of an appellate body should be more cautious, precisely because we have to acknowledge that members hold different views about how the system should work and even the nature of the system. While some members consider the appellate body like a kind of higher court, others, like the United States, believe is a different thing. And if we look at the scope of what the panels are supposed to do and the appellate body is supposed to do, they are two different things. The problem is that when we use the word appeal, for some legal backgrounds, appeal is the second instance or a second opportunity to get what you didn't get in the first instance. And it's not the case of the appellate body. The appellate body is supposed to deal with legal issues, errors of legal interpretation. Only if the panel really got it wrong in terms of legal interpretation or the application of the law to the facts, well, that's one thing, but it's not the same role as the role that has a panel. And I would say in terms of we still need to understand better what are the expectations of the United States. We know what are the concerns, and they have repeated those concerns for a very long time. This is not from the last US administration. But again, when it comes to the solution to those concerns, we don't have any clarity, or the expectations of the United States, we don't have any clarity yet. And I guess that's will be the subject of our conversations in the weeks or months to come. If we need to explore options, I would say that one way to deal with the US concerns, and I think that you are right, Jasper, there is a little bit of of true in the way that the United States is framing those concerns. It is true that when you look at all the cases cited by the US administration, you will find that, okay, it makes sense in some of them, many of them. It depends how do you see the different issues. But again, if we can distinguish the role of the panels and the appellate body, and then we can make the panel proceedings stronger, perhaps we will have less appeals to deal with and less opportunity for the appellate body to get involved in what the United States is claiming is creation of new obligations. And the way to do it is perhaps we should use more the interim review as an admissibility issue for an appeal, because you will correct me if I'm wrong, but sometimes it's a strategic approach of the parties not to comment on the interim review because they are saving those arguments for an appeal. And then the problem is that you bring in the appeal, but you didn't write in the panel, or the panel didn't know that they were making a mistake or a legal error in interpretation. So this is the kind of thing that we can discuss, of course, to make stronger panel proceedings and preventing the use of an appeal as an admissibility issue, for instance. And the second is that we need to be clear and instruct the appellate body to stick to its mandate. I fully agree that in law there is no black and white. There's many shades of gray, not only 50, by the way. There are so many more. But the thing is that when you come to an appeal and you say to the panel, okay, I would have done this differently, but I don't point to any error that you committed, then this element of arrogance, because you can decide cases in many ways. That doesn't mean that you had 2 or 3 different ways to resolve a case. 2 or 3 of the, or one of them will be erroneous. So this is the kind of thing that I believe we need to consider when starting the discussions with the United States, and hopefully we are going to find a creative solution to keep the main features of the system without, you know, altering much what was the original intention of the dispute settlement mechanism.
Thank you very much, Marco. Are there any other comments from the panelists? Natasha. I think you muted.
Apologies. With my good eyesight, I could see way in the back of the conference room that Alan actually had his hand up first. So I'll defer to him and then come in, but thank you, Carlo.
Alan, you have the floor. Sorry, you're very small in the picture, so I couldn't see the hand. The floor is yours, Alan. I think we had to unmute you remotely, but I don't have the power to do that. So I'm asking for Alan to be unmuted, if possible. You're still muted, Alan. Should I ask Natasha to make her intervention while we fix Alan's little sort of like IT issue? Please, Natasha.
Of course. Okay, thank you very much. The point that I was wanting to make is a slightly different one. It's responding, I guess, in part to Jasper's comment about what the utility of an appellate tier is and whether that's been a bit overblown by members. I think that, and the kind of examples that he cited, for instance, about the investor-state dispute settlement system and the fact that there's no appellate tier there, I think that the experience and looking at decisions that are made in the world of ISDS provide... Okay, Alan's back with us.
Okay.
Please, Natasha, go ahead.
Okay, thank you. So I think that when you look at the kinds of inconsistencies between decisions that are made in the ISDS world and the complete lack of certainty that it then results from the fact that your only sense of whether or not a particular measure will breach an obligation depends on the personalities involved with the 3 arbitrators that are being appointed. I think that that does not create confidence in a legal system. And I think that, you know, in the context of the WTO system, I understand that there's a motivation that the dispute settlement should primarily be about resolving the issue at hand between the disputing parties, and that there should be a lot of caution about making any kind of unnecessary or academic pronouncements about what the rules mean and then reifying that in subsequent decisions. I think that that is something to be cautious about. But the point is that any adjudication of a dispute involves an analysis of the obligation at issue. You can't resolve a dispute and not have some understanding of what the obligation at issue requires or does not require in order to determine whether a challenge measure infringes it or not. And that decision about the parameters and content of an obligation has clear implications for all members, not just those 2 disputing parties. And that impact and interest is recognised in the system of WTO dispute settlement by providing a role for third parties to participate in a dispute because they have a stake in how that obligation is interpreted. And I think that that's another aspect of where you look at needing to have an appellate tier in order to have some sense of coherence in the way that obligations are interpreted.
Thank you, Natasha. Alan, you have the floor.
Does it work now?
Yes, we
Does
can.
it work? Super. Okay. No, I just wanted to sort of come back on a few of the points that have been raised. I think the first one is, and it's, you know, it's not to avoid getting into a debate about whether the appellate body got it wrong or got it right, but I think we do need to look forward. You know, I think we've had the discussion about what went wrong. There's been sort of a lot of time spent on that. I think we need to start looking forward. You know, in looking forward, we don't necessarily have to think of the appellate body as it existed before. I think we have to be open-minded. But I think it's important to sort of move the debate forward as much as possible, looking at what can be done going forward, what kind of design for an appeal do we want going forward, or if you are in Jasper's camp, how would it operate without an appeal? And I think right now there's a good opportunity to experiment. And I agree that the United States plays a big role, and it's important to sort of bring them back into the fold. But to me, that shouldn't stop countries from experimenting. The MPIA is an experiment. There can be other experiments. The experiments can involve no appeals. They can involve a different type of appeal. They can, if one of the options is to have a dispute settlement system that is more of a first step to settlement, that can be tried as well. But I think the time has come to move forward and to start working on alternatives and experiment and encourage that kind of experimentation. And while we should always be open to starting a dialogue, particularly with sort of a player that was a frequent user of the system in the past, I don't think we should be paralyzed until that player comes to the table, or until it comes to the table with a more concrete agenda. And it's good that it's showing signs that it wants to come to the table. But there's no reason why we cannot move in parallel with bilateral, multilateral, plurilateral experimentation and pushing forward on any dialogue about improving the system as a whole.
Thank you. Thank you very much, Alan.
Carlo, can I quickly sort of have a comment on Natasha's point? I mean, and again, we all understand how tempting I guess it is when you're an adjudicator to impose your views or to explain why you think this provision means this particular thing, and clarification can be helpful. I personally think, and this is again potentially influenced by, for example, the way the European Court approaches a lot of these similar issues, right? With general language, and how do you implement that, and how do you clarify? You clarify, in my view, by applying the law in a particular way, not by replacing one set of words with another set of words. And to me, I think the most frustrating moment came when I was before the appellate body, and the presiding member of the appellate body asked the question, when we replace the words causation by a genuine and substantial relationship of cause and effect, what did the appellate body mean by that? And there you are as a party, say, what the hell? You replaced causal link by genuine and substantial relationship, and now you're asking me to explain what you meant by it, and how did it really clarify what really was intended by the drafters of the agreement? Apply it in a particular way, and as you apply the law to the facts, over time it will become clear. As we get more and more cases, people understand what the law means, in addition to the fact that the text is what it is. But I think that's where the appellate body has, in my view, felt that sort of need to explain, to clarify, and ultimately did not clarify. How many cases? And again, my experience serving on panels, and Carlo, I mean, you may have that same experience. You try to interpret. Someone talked about sort of USTR tie not being cryptic. Well, the appellate body hasn't always been what it would call a model of clarity in its positions, right? Things changed. Privatization cases, one time they said, arm's length market value, that there's no benefit anymore. But when the panel says that, they said, well, not always. Markets are mechanisms for exchange. Oh, what do we mean by that? So the constant changing, and or leaving certain things open so that maybe they could come back on it. That is, to me, is not clarifying the rules. The way the public body, to me, I don't have a problem with the appellate body saying what a public body means in a particular situation. I have a problem with the appellate body stating that test in 3-4 different ways throughout this case law. That is what's frustrating. And then you pretend to be clarifying, but you're not clarifying. I read the tuna TBT decision a number of times. I still don't understand. I can't follow the reasoning. It goes left and right, and maybe this, but also that. So I think the notion of the appellate body clarifying things by changing words and putting their own words into the text of the agreement has not helped. And I think, to me, clarification comes from application of the law in a particular set of situations. Now, in investor state, you're absolutely right, Natasha. People talk about, shouldn't we have an appellate body in order to have greater consistency and coherence? But then you see what, to a certain extent, this greater coherence leads to. It may be too much rigidity. Maybe we need that kind of flexibility where, if you have the right panelists in a particular situation, they would apply the law slightly differently. And I don't think there's complete the lack of consistency in investor state. You still have like a mainstream view, and from time to time there's a bit of a panel of arbitrators that goes in a different direction, but it remains more or less an exception. But so that's a big question we have, as the US complains about the precedent setting nature of the appellate body, for example, in that zeroing case law, of course. Is that what we want, or do we not want that suggestion of precedent? And then maybe we're better off not having that standing appellate body, which I think necessarily will always create sort of a perhaps a greater degree of coherence than is politically advisable.
Thank you very much, Jasper. We're getting towards the end of our time. I have not been willing to discipline time because the interventions have been so interesting and the discussion has been just so profound and fascinating. At this point in time, I would like to ask the participants whether there are any questions that you have for our panelists. Okay, I see one participant who asked a number of questions, said no more questions from me, and he's thanking the panelists for their interventions. I would still like to give the opportunity for a question. Other participants thanking the panelists again. Well, on my side, if there are no more questions, and as we are like approaching the end of the time that we had, I really like to take the opportunity to thank the panelists really for sharing their views with us in a manner that was absolutely frank and open, and that you will not see that many times on such important and probably, as one of the panelists said, existential matters for WTO dispute settlement. Personally, I know that none of the panelists and none of us has the key, the solution to the problem. And they said it to us, and who has it at this particular point in time. But personally, as a neutral spectator, I still work for the WTO Secretariat. I'm comforted in knowing that the panelists that we had today are players, and they are players on the side of governments and on the side of on the private sectors, finding a solution to the current crisis. And that gives me comfort, given the intervention that I heard today, and sort of like a great number of ideas and correct analysis of the situation that we have. So thank you very much for making the time to speak to our participants. It's very much appreciated. And of course, thanks to the participants for allowing us this opportunity and for being part of this. So at this point in time, if there are no more questions, you can of course sort of come back to us with questions that you have about today's session or any other sessions. I will ask the participants to remain on the call because our colleagues from the ITTC division have very important announcement to make to you, while I will thank the panelists and then of course hope to see them soon again.
Thank you very much. And indeed, on behalf of the organizers of this virtual executive trade course, I'd like to thank all of the panelists for sharing your perspectives, expertise, your experience, and for taking the time to be with us indeed, and for your frankness on this very topical and timely matter. So we very much appreciate the perspectives that you shared, and it really enriched our thinking and our gaining of knowledge on this topic, dispute settlement mechanism in the WTO. So thank you very much again. And of course, to our colleagues, Carlo and Tanya, for organizing and moderating this discussion. Thank you very much for your collaboration again. Now, this roundtable concludes our module 6 on dispute settlement procedures. And we will send you a link to the video as well as a link to the evaluation for this module. Now, as you may know from the program, next week we are taking a break to give you the time to reflect on what we have done so far and perhaps give you some time to review the materials in the Google Drive and the links that you have had. I'd like to make an announcement for our module 7, the last week of the course, which will take place in week of April 4th. And what we already know is the fact that on April 8th, on the last day of the course, on the Friday, we will have a live session. It will start at 14 hours at 2 p.m. Geneva time, and it will last for 1 hour. It will be a discussion and evaluation of the course as well as closing remarks. We will have a participation of our director of ITTC, Ms. Brigitte Chilala, as well as a chief of section for the strategic planning, monitoring and evaluation, Claude Trodier, who will join us for this closing session as well. So I'd like to perhaps ask you already to book your calendars, reserve the time from 2 p.m. to 3 p.m. Geneva time for this session. Let me also mention that here in Geneva, we will be changing the time to what we call the Central European Summer Time. So we go forward 1 hour. I'm not sure what that means for your locations, but you will need to figure it out whether you need to connect with us an hour earlier. But we call it the Central European Summertime, and we go forward with our clocks this weekend, in fact, 1 hour. So please make sure that you connect with us at the right hour so that you don't learn that you just missed us on the Friday, the April 8th, because we will start at 2 p.m. at 14 hours Geneva time. And as soon as we have information about the rest of that program on module 7, we would let you know. We already know, I think there will be 1 pre-recorded video, perhaps 2 pre-recorded videos for the topics that we have foreseen for that week, which will be the current issues discussed in the General Council as well as e-commerce. But as soon as we have information about it or the links, we will send it to you. Hopefully sometime, sometime next week, hopefully early next week if we can. So, so far, I just wanted to sort of pre-warn you about the live session on April 8th, the Friday at 2 p.m. And we will post our latest version of the general program as well, so you can consult it in the Google Drive. And as soon as we have information, more detailed information about the week 7 or the module 7 of the course, we will let you know as well. Do you have any questions about this planning for the last week of the course, which will be in the week of April 4th? I hope I have been clear enough, but if there is anyone who needs any clarification, please let us know. I do not see anyone asking for the floor, and nothing in the chat. Very good, no questions. So looks like everything is clear. So we will miss you for next week. We won't be connecting at all next week, but we will see you at some point, definitely on Friday the following week, and we will send you materials for module 7 as soon as we have it. So with that, I wish you all the best for the Thursday. Good day, good evening, and for the upcoming weekend. And We'll see you, and watch out this space for materials for Module 7 for the last week of the course. Thank you very much, and all the best.